our speaker is going to be doing justice to the roles and responsibilities of lawyers. With this, I want to welcome everyone, and I want to yield the floor now to the moderator, Mrs. Ladi Ochuboguju, to continue with the webinar. Thank you very much, and have a good listening.
Hello, everyone. Good afternoon. My name remains Ladi Ochuboju Abidoye. I'll be moderating this webinar this afternoon. Once again, you are all welcome. Before we invite our guest speaker to just want to state that the speaker will be taking notes on the topic already mentioned, the anti-money laundering laws, roles and responsibilities of a lawyer made simple. He's going to be speaking for 30 minutes, and while in the course of his teaching, if you have questions, please kindly put it on the chat box. Thank you. So with this, I want to briefly read a citation of our guest speaker today, in the person of Sunday Kenechukwu Agu. He's a seasoned legal professional with a strong dedication to access to justice and legal education in Nigeria. His career reflects a blend of academic expertise and practical experience in the field of law. He is a lecturer within the Department of Public and International Law, and also had functioned as the pioneer clinical law administrator, overseeing the running of the law clinic and designing and supervising clinical programs and projects at Base University, Abuja. This role highlights his commitment to clinical legal education, an area in which he has received extensive national and international training. Prior to his academic position, he served as a project officer at the network of university legal institution, Nigeria, where he provided technical assistance to numerous university-based law clinics across the country. In this capacity, he contributed significantly to projects focused on pretrial detention, access to justice, street law, student law practice, legal aid, and community justice education. His professional affiliations include membership in the Global Alliance for Justice Education, GAJE, the Teachers Registration Council of Nigeria, TRCN, the Nigeria Institute of Management, NIM, and the Chartered Institute of Arbitrators, UK. He's also certified arbitrator in both Nigeria and in the United Kingdom. Furthermore, he's involved in providing free legal education through radio shows. He is with the Public and Private Development Center, PPDC, where he had served as the Senior Programs Manager, Access to Justice, and now as the Institutional Partnerships Lead. This shows a continuation of his strong dedication to improving the justice system within Nigeria. Mr. Agu's academic credentials include an LLM, LLB, and a postgraduate diploma in education, demonstrating his commitment to both legal practice and education. His publications in local, regional, and international journals underscores his contributions to legal jurisprudence. With this elaboration, may I welcome to take over the floor our erudite speaker today in the person of Mr. Sunday Kenechukwu Agu. You are welcome, sir. Mr. Kenechukwu Agu, the floor is yours now, sir. You have 30 minutes to do justice to.
Okay, Mr. Kenechukwu, you are a co-host now, so you can unmute and speak.
All right, thank you very much. I was muted for quite a while. I was trying to make sure, yes. Thank you very much. I want to say a very big thank you to the Women Forum of the Nigerian Bar Association, Gariki branch, for putting this together. And I seem to be the only man in the midst of awesome women. I'm very grateful for giving me this privilege. Okay, I've seen some of my brothers here. Thank you very much for not letting me alone in the midst of the women. But our Women's Forum, we are doing well. And I must say it's a good thing that we are discussing this subject at this time. Our topic today is quite a very easy one, and easy and straightforward. Please confirm you can see my screen. Can someone just confirm they can see my screen?
Yes.
All right. Thank you very much. So we
see
are looking
you,
at
sir.
All right, thank you very much. So we're looking at anti-money laundering and combating the financing of terrorism, AML-CFT for short, the role of lawyers, and I dare say the role of female lawyers under our Nigeria's 2023 rules of professional conduct. And I'm going to give us this case study. Unfortunately, we're not able to speak, but if you can type in the chat box so that I can see. So Mrs. Madam has briefed you to handle a high court case for her younger brother in a civil action. Madam paid your professional fees in full. Madam wants you to send her a report or update on the case from time to time. What will you do? I'm sure most of you must have heard during the presentation that I'm a teacher, so I prefer to be quite interactive. See your comments. Let me get a few comments and then we would proceed from there.
Mr. Kenechukwu, are you still there? I guess we lost him for a bit. Probably network. He will connect with us shortly. Mr. Kenechukwu.
Sorry, I think my network put me out, but can you confirm I'm back now?
Yes, sir, you're back.
Oh, okay. All right. Okay, thank you very much. I could see for this year's response. Yes. Prepare a report on all activities carried out so far, the expected outcomes and timelines. Okay, she says she would prepare that report. Can someone just
Mr.
reply?
Kenechukwu, sorry, please. We can't see your screen.
Can you see it now?
Hello? Not yet. Okay, yes.
Okay.
Kindly go.
All right. So waiting for responses. Only producer has responded. Okay. So my question is, what will you do? Will you give her the report that she has requested, or will you not give her the report? Esther also says she will prepare the report on the outcome of the case, okay, and keep her updated. I will give the report from Sarah. Thank you very much. Fredorsi, Sarah, and Esther, thank you very much for your responses. But do you agree with me? Does anyone see any potential conflict of interest here? Does anyone see any potential conflict of interest here? I'm going somewhere, with doing this with this question. Yes, Shama sees the potential conflict of interest. Yes, thank you very much. So the thing is, right, on the face of it, this does not look as if there is anything. Yes, she is not the client, but Sarah, you said you were going to provide the update, but you know that she's not the client. Thank you very much, Tamara. Thank you very much. Even if she's paying, she's not your client. Your duty is to your client, not to the person paying, right? So I did this illustration to show us, or to make us understand, that there are things that may not look on the first phase of it as though they are wrong, or there is anything wrong with it, but there are actually ethical issues. She is not the client, and it's the brother's case. If the brother wants to give the report to her, he can do that on his own. But as a lawyer, your duty is to your client. So this is just for us to understand that there are situations, especially when it deals with ethics of our profession, that it may not look like it on the face of it. But deep within, when you read it well, that is where the issues lie. So that underlines the reasons, or underscores the reasons why MBA has gone ahead to set up our anti-money laundering rules as part of our rules of professional conduct of 2023. Whether we like it or not, the legal profession has been placed as designated non-financial institutions. What are designated non-financial institutions? Designated non-financial institutions are those institutions that, though are not financial institutions, are non-financial institutions, but handle finances. So they have been designated to fall under the Money Laundering Act as institutions that must have some level of responsibility. So like I said during the Gariki branch meeting last month, that look, the reason why MBA have done this is so that we will self-regulate. We need to self-regulate. So I see Morenike is saying she briefed you in the first place. Well, if you look at the case study, really, she didn't brief you. She only referred you for her younger brother's case. And the younger brother is your client. But let's move forward, right? So if you look at Justice Abiru, what Justice Abiru said to us in the case of Usman and another versus Federal Republic of Nigeria 2018, he reminded us that a barrister cannot pick or choose his clients. He is bound to represent whoever has come to him, and that is when we talk about the the rules that talks about the cab rank rule. So let me read exactly what Justice Abiru told us. Justice Abiru says a barrister cannot pick or choose his clients. He is bound to accept a brief of any man who comes before the courts, no matter how great a rascal the man may be. And he went on to say he must accept the brief and do all he can honorably on behalf of his client. And he made reference to Rule 24, sub 1 of our rules of professional conduct, which we ordinarily referred to as the cab rank rule. Now, it is a mistake again for you to suppose that you are the mouthpiece of your client, to say what the client wants or his tool to do what he directs. He is none of these things. The lawyer is neither a mouthpiece nor the tool of the client. A lawyer owes allegiance to a higher cause. It is the cause of truth and justice, and he must not consciously misstate the facts. He must not knowingly conceal the truth. He must produce all relevant authorities, even those that are against him. He must see that his client discloses, if ordered, the relevant documents, even those that are fatal to the case. He must disregard the most specific instructions of his client if they conflict with his duty to the court. Yes, we've learned to owe duties to our clients, but we owe a higher duty to justice. We owe a higher duty to the courts. So today, essentially, we are going to be talking about understanding the anti-money laundering and anti-terrorism obligations for Nigerian lawyers, the AML-CFT, as I'll refer to them moving forward. We'll look at the new requirements under the 2023 Rules of Professional Conduct. We'll look at the practical compliance strategies. We'll look at risk management and due diligence procedures. And then we'll discuss why does this matter. Number one, like I've said, is that lawyers are now designated non-financial institutions. There is increased regulatory scrutiny and enforcement. There is professional liability and reputational risk that are attached. And of course, Nigeria is committed to international AML and CFT standards. Now, let's start with the regulatory framework overview. What are the key regulations, the key laws and regulations that deals with this subject? The primary legislation is, number one, the Money Laundering Prevention and Prohibition Act of 2022. We also have the Terrorism Prevention and Prohibition Act of 2022. We have the Economic and Financial Crimes Commission Act. We also have the National Financial Intelligence NFIU Act of 2018. Now, what are the professional regulations that stem from this? Of course, the rules of professional conduct has provided for us in 2023, reviewed by the MBA. Of course, you know that the RPC is made pursuant to the Legal Practitioners Act. So it's not just a rule, it's a statute somehow. So there's also the Legal Practitioners Act and of course the NFIU guidelines for legal practitioners. For international standards, we have the Financial Action Task Force, FATF recommendations, the Egmont Group principles, and the Egmont Group principles. Now, let's look at the 2023 Rules of Professional Conduct. What are the key provisions on AML-CFT? Number one is Rule 55, which gives us the objectives for Chapter 2 of the Rules of Professional Conduct. Number one objective is to promote compliance with the AML, CFT, and PF legislation. Number two, like I've told us, is internal self-regulation and discipline of the legal profession. Number three is to enhance lawyer-client confidentiality privilege ethically. Number four is for us to adopt a risk-based approach to identifying money laundering and terrorism financing situations. If you don't understand what the risk is, you may not be able to really appreciate what the situations are and why there is a need to even follow through with the rules that have been provided. Now, Rule 57 talks about reporting and compliance obligations on our part. It says that a lawyer must conduct an internal risk assessment for money laundering, terrorism financing. And it applies to all legal arrangements with the clients. failure to do this constitutes a professional misconduct under the Legal Practitioners Act. So to avoid falling under this professional misconduct, you must report. There is a reporting and compliance obligation as provided for by Rule 57. Now, the exception here is only for mere notarization and certification of documents. So if you are doing your job as a notary public, you are not expected, or you are not obligated, rather, to report. Now, Rule 58 provides us with a record-keeping requirement. You are expected as a legal practitioner, as a law firm, to maintain accurate records of domestic and international clients. You must keep clients and transaction records for a minimum of 5 years, and all records must aid easy client identification. Now, we move forward to the fact that we are now a designated non-financial institutions, right? Now, when lawyers become a subject of these AML-CFT rules, understand what we mean by this. You are obligated under these rules when you are a DNFI. When you have been designated the non-financial institutions. What does this mean? When you are carrying out the following services that are covered. One is real estate transactions. If you are, hello, can someone confirm they can hear me? I hear the recording has stopped. Hello, can the host confirm I'm being heard, please?
Yes, sir, you can go ahead.
All right. Thank you very much. So when a lawyer becomes subject to these AML-CFT rules is when you are doing real estate transactions, when you are buying or selling property. And for those of us in Abuja, we know that real estate transaction is one of the ways lawyers, we make a living in this part of the country. Abuja has been said to be one of the largest city with ongoing constructions in Africa. So we cannot deal without real estate. Nobody is saying you should not do real estate, right? But when you're doing a real estate transaction as a lawyer, when you're buying or selling property on behalf of a client, you fall under the AML-CFT rules. When you're doing company registration, corporate formation, or you are managing a company, you fall under the AML-CFT rules. When you're operating a trust or you're doing company service provision, you fall under the AML-CFT rules. When you're managing client money, securities, or assets, you fall under the CFT rules. When you're doing financial or business transactions exceeding 5 million naira on behalf of the client, listen to the keywords, is financial or business transaction exceeding 5 million, above 5 million on behalf of your client, you are covered under the AML-CFT rules, and you are obligated to abide by the rules. Now, there are activities that are excluded. Court representation and litigation. You are not expected to report your court representation or litigation. The AML-CFT does not cover those. If you are just giving mere legal advice or consultation, you are not expected to cover those. If you are preparing a will that does not include asset management, if you are preparing a will that does not include you managing the assets, you are also not obligated under the AML-CFT rules. The key principle here is that, of course, if you're doing academic or theoretical legal work, you are not obligated under the AML-CFT rules. But the key principle is that once it is a transaction-based coverage, once what you're doing for the client is transaction-based, once money is going to flow from you on behalf of the client to another person, you are doing the duty of some financial institutions, and that is why you are a designated non-financial institutions. Of course, you know, when we talk about money launderers have different layers of money laundering. Money laundering deals with, placements, layering, and integration. So if you are carrying out any activity on behalf of your client and you fall under any of this spectrum, it is a transaction-based, and therefore you are covered under the AML-CFT rules. Please make no mistakes about this. There is no blanket application. It is not a blanket application. So don't go on saying that, oh, lawyers are now to do this. No, it is a service covered arrangement. It is a service covered program. And I believe we should be grateful to the MBA from saving us from what the EFCC, NFIU wanted to do before, which is to bring every legal transaction under the purview of the Money Laundering Act, right? And with what MBA has done and with what the court has held in the various cases that have been decided on this subject, that you don't have to give out what your client has given to you in confidence. And that is why certain activities have been excluded. Now, there is what we call the customer due diligence requirements. And these are found under Rule 61 to 67 of the Rules of Professional Conduct. Now, this customer due diligence and enhanced due diligence in Rule 61 says that you should identify and assess money laundering and terrorism financing risk for specific services. You should develop internal mechanisms, policies, and procedures to combat this. And what do we mean by internal mechanisms? Simple things. All of us go to hotels, right? When you go to hotels, you submit your ID card, they give you a form to fill. It's as simple as that. A client walks in, wants you to do real estate business for them, simply give them a form to fill. That form, we are not submitting it to anybody, but the committee, which we will soon see, as has been set up by the Rules of Professional Conduct. So you must also reasonably identify clients and potential risks. Then you should seek assistance if you lack requisite expertise in this area. If you want people, if you are not sure you understand what the provisions are with this regard, look for people who understand it to help you set up your due diligence framework, to help you set up your CDD. Get consultants, get senior lawyers, reach out to people who are knowledgeable in this area to help you sit down with your practices, with your partners, with your procedure, with what you have in your system to be able to look at if it complies with the CDD and EDD. CDD is the customer due diligence and EDD is the enhanced due diligence. Now, Rule 62 gives us a risk assessment categories. First thing to note is that there is no universally accepted methodology. Our rules only provide a guidance. Now, the categories for risk assessment include geographic risk, client risk, and transaction risk. This place this person wants you to go and do this transaction, does it pose a geographic risk in terms of money laundering or in terms of terrorism financing? Somebody comes, wants you to go buy a property for them in South Sudan, for instance. And you ask yourself, why South Sudan? Why does this person want to move the money to South Sudan? You must consider the geographic risk. You must also now consider the client risk. And for the records, I only mentioned South Sudan because we know that there's a trouble in that area now. And I believe I'm speaking to Nigerians, so they get what I mean by that. Now, client risk. Who is this client? Does it pose any risk in terms of money laundering or terrorism financing? Transaction risk is also there. What is the transaction? So we are saying that your risk assessment should actually be based on a risk-based approach to service delivery. You must also show evidence that you have complied. And this evidence will include compliance documents stating the practitioner's understanding of the process, affidavit on transaction genuineness and source of funds, and then essential transactions information documentation. Now, there are also issues around beneficial ownerships, right? For you to understand transactions you are doing, we need you to understand who are the beneficial owners. And for some of us who are doing CAC transaction, we see that if you want to incorporate companies now, they want to identify who are the beneficial owners of the company, who are the real controlling shareholders of the company, on who are this whole, yes, a business is a separate entity, but there are people behind the business. So we need to know who are the beneficial owners. For corporate clients, you have to identify who the natural persons are, who own equal or approximately 25% of the shares and voting rights. Who are the people who control through other means? Who are in the board? Are there compositions? Are there joint venture agreements? Are there business agreements that are affecting this business? So someone approaches you to register a business. You have to find out who is the natural owner of this company, who has the controlling shares or controlling votes, who has the ultimate controlling natural person, if the person is not a qualifying shareholder. For trusts and foundations, you must know who the settlor is. You must know who the trustees are. You must know who the beneficiaries are, current beneficiaries and potential beneficiaries. You must also identify any other natural person who's going to exercise control over that trust or that foundation. So in drafting wills for people, you must understand what these things are. Documentation that are required. You must have your corporate structure charts for them, share registers for them, trust deeds and amendments, and board resolution. It's no longer just enough that you copy and paste what CAC provides or you adopt what CAC provides. When you do, please, my brothers and sisters, print it out and keep it. Print it out and keep it to save your head under these regulations. Now, there are risk categories under the 2023 rules. Rule 63 to 65 provides for comprehensive risk assessment framework, which is what we discussed previously. Rule 63, geographic. Rule 64, client risk. Rule 65, transaction risk. If we go through those rules, you will understand exactly what it's talking about. There are countries identified as credible sources as terrorism financiers. There are countries, there are areas, there are regions that have sanctions. There are regions that have existing sanctions and embargoes. There are jurisdictions with weak AML-CFT regulatory framework, AML-CFT safe havens. Those are high-risk areas in terms of geography. For the client, is the person a politically exposed person or a related entity? Just things in that direction as I've discussed earlier. Now, there are U.S. sanctions and suspicious transactions reporting. Rule 60 and Rule 73. Rule 63, they talk about the sanctions, compliance, and reporting framework. Rule 60 talks about the UN targeted financial sanctions, right? We must implement mechanisms for UN sanctions on terrorism and proliferation of financing, right? We must screen all our clients against UN consolidated list and Nigerian sanction list. For most of us who are not yet there in terms of, transacting at that level, it's just for you to know it, right? But our committees, we are not reporting to UN. We report to the MBA committee. The MBA committee will now be the ones that will transmit, if necessary, to the NFIU. Now, you also maintain professional identity while doing your reporting obligations. Your prompt reporting is required upon identification. There's the legal protection, which is that the reporting, what does this reporting do for you? This reporting provides you with, legal protections in terms of it complies with ethical duty of confidentiality. It also helps you protect you for good faith reporting. It doesn't breach lawyer-client privilege for factual reporting. Now, record keeping and documentation, like I've said, you have to keep your client's records for 5 years, identify verification document, beneficial ownership information, CDD and EDD documentation and risk assessments, transaction records, and instructions. These are the things we want to see when they come to, when they come to your law firm, when they come to your practice to see if you're complying. For your internal records, you must have the risk assessment procedures, staff training records that you've trained your staff on this thing. So those of you who are attending this program now, attending the ones organized by MBA, is proof that you are training yourself, you're training your staff on this process. AML-CFT policies and procedures. Every law firm, every lawyer should now go ahead to develop their own internal AML-CFT policies. The rules allows you to generate your policies in line with the guidelines provided by the Nigerian Bar Association. Now, best practices is for you to keep your digital storage and backup systems, have an organized filing system, regular review and update meetings, and secure access controls to your document. For you to do risk assessment and management, right? One, you have to develop your AML-CFT framework. There is a firm level risk assessment, client level risk assessment, and then you now go ahead what we call ongoing monitoring. I'm trying to be fast, so I keep to time. This is actually not a session that can be finished in one day, but we are making progress, right? So for your staff training and awareness, you must build internal capacity and the culture. There are training requirements for your staff, initial training for our staff, regular refresher training, role-specific training programs, update on regulatory changes. You must show that you're doing this. Now, there are key training topics that you have to be trained on. Like I've said, what we are just doing is an overview. If you look at the presentation, I've just highlighted key training topics, about 5 of them that you have to train if you really want to understand this. And you have to train on recognizing suspicious activities, CDD procedures and documentation, STR preparation and submission, that is statutory transaction report, suspicious transaction report preparation and submission, professional obligations and protections, consequences of non-compliance. These are 5 key areas that can take each day of maybe 1 or 2 hours to train if you really want to understand this. But for documentation, you have to keep your records, competency assessment, training materials, and individual training files. Now, you can leverage technology to comply with this process. And how do you leverage technology to comply? You can have a client onboarding platform, an identity verification system, a transaction monitoring software, a document management system. I don't want to advertise any brand, but look for any of these platforms that you can use. I've not been paid to advertise any brand, but if you ask me personally, I can give you some tips on which ones you can use. Some of them are free, some of them are paid for. But mind you, there is really no free lunch, even in Freetown. So even when they say something is free, you really need to understand to what extent or how free is that. Database screening and the benefits of that. The benefits of using technology is just numerous. It helps you improve efficiency and accuracy. It enhances record keeping. There's real-time monitoring capabilities, and there's reduced manual errors or human errors, as you may wish to call them. Now, what are the common red flags and warning signs, for you to start talking about how to recognize suspicious activities? I'm just taking this in bits, right? 1, you look at the client behavior. If the person is reluctant to provide identification or information, I had a cause to have a call with a law firm in Canada recently. And before they spoke with me, I had to present my ID card. They took a snapshot of my ID card before the meeting started. A virtual meeting. They were the ones who invited me to speak on something, but I had to present my ID card to get that. So when the client is reluctant to provide identification or information, it's a red flag. When the client provides false or suspicious documents, it's a red flag. When there is an unusual nervousness or evasiveness, there is a red flag. When the person is insisting on secrecy beyond the legal privilege, there is a red flag. Now, for transaction patterns, when someone just comes and dumps on you large cash payment without clear source. So, help me do this transaction. I need to buy this land for 1 billion. And then he sends 500 million to the people and then gives you 500 million cash. It's a red flag. Or rapid movement of funds across jurisdictions. Money is moving from Nigeria to Dubai, to UK, back to Nigeria, to Canada, back to Nigeria, my sister. That is a red flag. If transactions are inconsistent with the profile of the client, that is also a red flag. When they use multiple accounts or different people coming to give you money. There was one tenant one time who, Cecilia, I can see your hand, but can we take the questions after we are done, please? Because of time. Thank you very much. I had one tenant one time in one of the properties I was managing who, sorry, for a rent of about 2 million naira, more than 6 people sent me money. for that particular transaction. That is a red flag if the amount, of course, is more than 5 million. The threshold is 5 million, right? So if there are use of multiple accounts or intermediaries, it's also a red flag. Sorry. Now, there are also business structure red flags. If there are unnecessary complexities in the corporate structure of that business, it's a red flag. If a use of shell companies without clear purpose, oh, I have this company, use this company to buy the property, don't worry. Madam, what does the company do? Madam, what is the purpose of that company? Frequent changes in beneficial ownership. There's a company, more than 15 people. They have changed directors more than 15 times in a space of 5 years. It is a red flag. Now, oh, I want to do this transaction, but I want to do it in a jurisdiction where there is a weak anti-money laundering and terrorism financing controls. That is a red flag and a warning sign for you as a lawyer. Sanction compliance, I've talked about this compliance. Like I said, these are things that will take us different hours to deal with them, one after the other. Regulatory enforcement and penalties. The criminal penalties for money laundering is up to 15 years imprisonment. For terrorism financing is up to 20 years imprisonment. Failure to report is up to 2 years imprisonment. And there are substantial fines and assets for future. Now, for sanctions, we can have NFIU, administrative penalty. Your license can be suspended. There can be a proper disciplinary action. And of course, it damages your reputation. And we as lawyers, we know that our reputation is one of the things that we pride in, that we trade with. For civil liabilities, of course, there can be third-party claims, there can be asset recovery actions, and professional indemnity issues. Now, client confidentiality versus this money laundering and CFT obligations. How do we balance the professional privilege and our reporting duties? Number one, legal advice and litigation communications are not to be reported. They are protected. What is not protected is client duty. The identity of your client is not protected. Your fee arrangement is not protected. Transaction details is not protected. Now, AML CFT disclosure, you must submit suspicious transaction reports. It does not breach privilege because what you are submitting is client identity, fee arrangement, and transaction details. You are not talking about what the person asked you to do. You are not disclosing the brief of your client. You cannot disclose privileged legal advice content. It's not allowed by the law. It's not allowed by the rules. So I hear lawyers argue that, how do you expect me to come and give you the details of my client? Nobody says you should give details that your client has provided to you. What the law says is that you should disclose identity, fee arrangement, and transaction details. Simple. Now, what is a practical approach to get this balance? Separate your transaction services from legal advice. When you're helping people to buy property, it's different from when you are advising them on the property. Have a clear engagement with your clients that defines the clear scope of your engagement, right? Document your claims appropriately and seek legal advice when on sitting. Don't be too big to reach out to your senior colleagues to say, look, how do I do this to make sure it doesn't affect, I don't flout any of these rules. Of course, there is international cooperation and information sharing. Nigeria belongs to the FATF, we belong to the Egmont Group, and we belong to JABA. JABA is the Intergovernmental Action Group Against Money Laundering in West Africa, right? And of course, there is mutual legal assistance, and the implication for lawyers are also very good, because if we belong to this, Nigeria belonging to these organizations helps us that we can share information. There is cross-border enforcement, and there's enhanced due diligence for your foreign clients, and there's compliance with international standards. Practical steps to help you do that. Build your compliance program. I have said this again. Conduct your immediate risk assessment, develop your own policies, implement your CDD and your EDD, establish record-keeping systems, train your staff on the requirements. Emphasis on staff, not just your lawyers. Train even your clerks working with you, secretaries working with you on these requirements, right? Now, the best practices for me, number one, is that you should appoint a dedicated compliance officer that deals with this so that you don't bother yourself with this process, right? It's also a job opportunity for young lawyers because firms are not going to look for lawyers who have expertise in this area to deal with it. Also have regular internal compliance, technology investment for efficiency, professional development and training, industry network and knowledge sharing. These are best practices. Now, right, let's look at this case study. So this case study is a trust fund with anonymous donor, right? A law firm in Abuja led by Mr. Ibrahim was hired by a client, to fund her charitable, a client, Mrs. Chukwu, to establish a trust fund for her charitable activities. The trust began receiving large donations from anonymous sources. So let's say your law firm, right, has been hired and you're asked to establish a trust fund for, she just says her charitable activities. And then before you know it, you establish that, incorporated trustee, and then large donations from anonymous sources. No name, no nothing. You can't trace it. There are anonymous sources, right? This case study. One is the suspicious activities here are that one, the anonymous donations. If the donations were made in cash or through untraceable wire transfers, you are clearly helping that person perpetrate money laundering. If the purpose of the trust is unclear, somebody wants you to register NGO and he says anything, I just want to be like Very Dark Man. I just want to be like that Threes. I just want to be like, what's the other man now that does plenty giveaways on Ashakin? That, Ashakin now takes young women, young girls to out, and he just wants to be doing things. So there is no, sorry, don't get me wrong. I'm not saying these guys don't have a clear purpose. I'm just saying someone meets you and says, I just want to be like, what is the purpose of the trust? What is the purpose of that organization you want to set up? Right? Then there is also high-risk jurisdictions. Where did this money come in through? Which countries did they come from? So your best bet is to warn your client, Mrs. Chukwu, on these things and to be careful as a lawyer as well. Then there's also lodgement of funds into a client account in excess, someone comes and pays in a huge sum of money. Say, lawyer, they get one work, where you go do for me. Hold this money first as they come. They never tell you the work. Sorry for my pidgin. God help me. Sorry, I was trying to say in a way that most of us will understand it better, right? They've not told you what the work is. They've not told you what you're to do, but money has been sent to you. Or somebody pays you an excessive legal fee. I know we will say what is excessive. If you've negotiated for an amount and the person pays higher than that, of course, they will ask you to send it back. My sister, you have turned to a money laundering helper. Now, there are resources and ways you can get support. I'm sure they will share these slides with you guys. So I'm not going to waste much time on that resources where you can find the resources there. They are there. I've put the website to also help you get the resources that you need. But let me talk about Rule 73 quickly, which talks about the MBA Money Laundering Committee. The committee has composition and qualifications, persons with adequate AML-CFT training and knowledge, persons of repute in the legal profession, must not have been found guilty of money laundering or related activity, and MBA will ensure adequate training of these committee members. But what is the function of the MBA Money Laundering Committee? First is to advise MBA on implementation and monitoring of Chapter 2 compliance. When I mean Chapter 2 here is Chapter 2 of the Rules of Professional Conduct. 2 is to identify money laundering and terrorism financing risk and adequacy of existing control measures. 3 is to develop policies for identifying at-risk legal practitioners. 4 is to create a supervisory framework for verifying beneficial ownership information. 5, conduct risk-based assessment examinations for law firms. 6, report examination reports to SCUMUL. So it is this committee that will report to SCUMOL and not the law firms this time around, right? So, and they have the enforcement powers reside in the Legal Practitioners Disciplinary Committee, but the committee would, this MBA Money Laundering Committee can recommend disciplinary proceedings to the LPDC. They can also take appropriate measures against violating practitioners, and it is the principal MBA arm for addressing money laundering and terrorism financing issues in the legal profession. The goal is we have now self-regulated. And if we have self-regulated, let us actually deal with the issues that are facing us as lawyers together as colleagues. Thank you very much. I know I must have bored some of you, but thank you for listening to this introductory overview on this subject, and we are open to take questions if the host and moderator permits that. Thank you very much.
Thank you very much, Mr. Kenichukwu. That was very insightful. I personally have learned a lot of things that we casually do as lawyers. Now we understand that the practice is evolving. Thank you very much, sir. Please, we have some questions, and then I also want to say that if we have more questions, we could, go to the chat box and put in our questions. So, sir, Mr. Kenichukwu, the first question, I'm sure you can see, but let me read it out. The first question is, what is the procedure for reporting to the MBA? Then the second one, what if the client wants you to draft transaction documents and nothing more? So those are the two questions.
Okay, let me take the first.
All right.
The procedure for reporting to the MBA will be communicated by the MBA committee. The committees have been set up by the president of the Nigerian Bar Association. I'm not exactly sure what their requirements are now, but now because we are lawyers, well, this is recorded. So there are some things I may not want to say on record, right? But there is a reporting procedure by the MBA, and that is communicated. I can look at the links that was shared those times and all of that, and share that also with us, with the Women Forum as well. But there's the committee. The committee is there. The committee is supposed to go on inspection. Now the question again now comes up: who funds the committee? How will the committee carry out these activities effectively, right? So those are other questions. If I was not maybe speaking on overview, if I was critiquing that section, if I was critiquing that chapter of our rules of professional conduct, these are issues I would have raised. But the committee is supposed to go on inspection, like we saw what their mandate is. They're supposed to go on inspection and you submit that to them. I also assume that each branch is supposed to have a money laundering committee. It cannot be just the one set up by the MBA, but those are modalities that will be discussed with the MBA to see, because it is at the branch level that this implementation can take place. But my answer would be that pending when they come, keep your documentations ready. The committee is still busy doing trainings. They are still moving around doing trainings. By the time they are done with trainings, we will come around the implementations. Thank you very much. The other question was if the person wants you to do just documentation. Yes, do the documentation. It's not a transaction. You are not the one doing the transaction. The money is not passing through you. However, keep records. Keep your records. This person asked you to do this documentation. Yes, you did the documentation. This is his identity. The payment they gave you for that transaction, this is how it came. Bam, you are good to go. Thank you very much. Can we take any other ones?
Yes, sir. Thank you very much for those answers to the question. So the third question says, where you work as an in-house lawyer, how do you protect yourself?
I'm not sure if that is clear, but if you are working as an in-house lawyer, encourage you're working as an in-house lawyer for a firm or for a company. If it's for a company, you are not there as, it will be better to get more clarity on that question. really. But at all times, I would say as lawyers, keep your documentations. Make sure your documentations are clean and kept and your records are there for at least 5 years.
Is there any other question? Thank you very much, Mr. Kenechukwu. Before we wrap up, is there any other question? And in the absence of any other question, I this is a good place to call on Mrs. Sarah Edwin Inegedu for her vote of thanks. Mrs. Sarah.
Okay, somebody, Joel Paul Musa wants to ask a question. Yes, so the person's hand has been up since, so I think the person should probably go first. Then I will allow Miss Sarah Edwin to unmute as well.
Okay, that's fine.
All right, Joel Paul, please, you can unmute.
Hello?
Joel Paul, you can unmute. Please go ahead.
Okay, good afternoon, ma'am. Can you hear me?
Good afternoon.
Good afternoon.
Okay. The session was truly insightful. So my question is, I work in-house, okay, with a real estate company, and then just want to get perspective, right? Is it possible to, is it legal? I think that's the context of my question, whether it is legal to, receive payment for properties that are listed in Naira, in dollars. That's the first tranche of the question. And if that's legal, so is there like a limit? Is there like a limit of, how much you can receive for properties in dollars, for properties that you have listed in Naira, especially maybe when clients bring this kind of monies in cash, right? And then what's now the proper way of declaring these funds? Yes, we do the whole SCUMO declaration and all of that, and filing SCUMO report, but how do you go about this, and what kind of documentation now can you use to protect the company now for these kind of transactions? What kind of documentations would you use to protect the interests of the company in transactions like this? Thank you very much.
All right, thank you very much, Joe Paul. Some of your questions are very direct, and I like that. Probably we can have a session with people in real estate or your company to give you more practical insight on how to do that. But let me answer the more generic ones. One, Nigeria, you are not allowed to charge for services in any currency other than Naira or Kobo. See the CBN Act. That's a general answer. Because we are on record and we are on YouTube as well, it's good to put this out there, right? But the other thing I would speak to, you asked how you protect yourself as a lawyer working in a real estate company. Is that money paid to you or to the company? If it's to protect the company, please seek legal advice. Help them set up what to do to solve that problem. But if it is to you as a lawyer, you should not collect the money on behalf of the company, unless if it is a part of your job description to receive monies on behalf of the company. As a legal practitioner, please don't, particularly if it involves, cash, large sums. And there is a limit, because if you go to deposit those sums in cash in the bank is going to report to NFIU. It's going to report to EFCC. It's going to report even to DSS. I think that's the first question. Your second question, can you say that again so that I get the exact question, please? if I've not touched on that.
Okay, thank you very much. Thank you very much, sir, for this response. So the second question was actually the limit. The first question was whether it was legal or whether it is legal to accept, payment for properties listed in Naira in foreign currencies. And then the second question was, okay, what's the limit, of monies that can be received in this kind of transaction? And then the third question is, okay, although your question now, your response to this now is that is not allowed. So the third question was actually, if it is allowed for a company, what kind of documentation, what kind of agreement or contract document or whatever can be executed between, say, the company now and the purchaser to cover this kind of transaction, stating situations like this. That's just basically the
Yeah,
question.
basically just ask them to make a cash deposit in the bank. Send them to the bank. If they don't want to go to the bank, that's a red flag. You understand me, right? If they don't want to go to the bank, it's a red flag. So don't do that. And like I've said, if your real estate firm where you work with, I believe you are the legal officer there, you can propose to them too that you need some of training. It can be a day, an hour or two training on how to put your processes together, or people to come and help you arrange your processes together to make sure it complies. Because this is a recorded, is a recorded session. It's also out there for everybody. It's not something that I can speak to you directly here, but feel free to reach out to me on LinkedIn, social media, or any other place. My name is Kenechukwu Agu, or Sunday Kenechukwu Agu on LinkedIn. Let's take it up from there.
Thank you very much, sir. So, sir, we have another question here, and it says, speaking about suspicious transactions, is it that the lawyer is to decline the brief or to?
Hello, can you still hear me?
Yes, sir, loud and clear. Yes.
All right, so I'm going to take us for that answer. Let me take you back to the first warning I gave from Justice Abiru. That was why I started with that warning, that you cannot pick and choose your clients. We are not saying you should decline a brief. We are just saying report it to the committee. Simple. And you're not reporting what the person has asked you to come and do. You are reporting details of transaction, identity of the client. I don't know if that makes sense now.
Thank you very much, sir. Yes, sir. That makes sense, sir. Well understood, sir. So
Yes.
in the absence
Okay, there's one more person that wants to ask a question orally. Mrs. Sarah, you can unmute.
Okay. Good afternoon, everybody. Good afternoon. Can we all hear me?
Yes. Good afternoon, ma'am.
Okay.
yes,
Good
we
afternoon.
can.
Thank you. Thank you so much, everybody, for joining. My name is Sarah Edwin Inegidu. I'm the alternate chair for the MBAWF Garki branch under the Abuja chapter. So I'd like to first of all thank everybody for your time. Thank you, Mr. Kenechukwu Agu, for the insights and the wealth of knowledge that you have impacted us, that you have impacted on us here today. It's very invaluable, and we really and truly appreciate you, sir. Thank you so much, sir. I'd also like to take this time to recognize the FCT chapter state lead in the person of Mrs. Hadiza Afigwa. Thank you so much, Ma, for taking out time to be with us. Thank you for your continuous support and for your leadership. We truly, truly appreciate you, Ma, for all you do for us in the FCT chapter. We never feel alone because you are with us. Thank you so much, Ma. To everybody that took their time out from Lagos, from Kwara, from Delta State, from different parts of the Federation, we thank you so much for gracing us with your presence. At a point, we were up to 74 individuals, participants on this group. Thank you so much, everybody, for your time. Thank you so much for gracing the maiden webinar session by the Garki branch of the Women's Forum, the MBA Women's Forum. We are so grateful. We are so thankful that you took time out to be with us. On that note, I'd like to wish us well. And just to let you know that you should please stay tuned for more webinars from us, more activities from us in the Garki branch as well. There'll be such events would be publicized to everybody from time to time. Also, for those who are interested in joining the Women's Forum, the FCT chapter, or the Women's Forum generally, there's a website available, details of a website available, which can be shared on the different platforms that we joined from. And if you could drop your phone number in the chat before we close the webinar, somebody will take your details and add you to the FCT group. So yeah, welcome. We also have an Instagram page, Women's Forum, Abuja Women's Forum, MBA Women's Forum Instagram page, Facebook page as well. We're also available on Facebook as well. So you can get details of the activities. You can get details on how to join on the social media platforms apart from the website. Instagram, Facebook, MBA Women's Forum. If you search for it, you'll be able to find it. Thank you so much, everybody, for your time, for your presence. Thank you once again to our speaker, Mr. Kenechukwu Agu. We are so grateful. And let me just use this as a way to tell you that we will call you back on other topics as well. Just take yourself as an honorary member of the MBAWF. Key branch is already adopting you. We have coopted you. We have adopted you as an honorary member, sir. So I hope you will accept.
I hope you are going to give me my pink muffler. I'll get my pink muffler.
Yes,
okay. All right. Thank you very much. I must say a big thank you to the Women Forum for all you do. I'm very grateful for thinking me fit to speak at this session. And the fact you said you invite me again has meant that I have not bought so many people, maybe just a few persons that have bought this afternoon. So I look forward to more interactions with you. Thank you very much. And please permit me to leave now. I'll have to rush out to other things. Thank you very much and have a great day.
Thank you so much, sir. We appreciate you, sir.
Thank you very much.
Bye.
Yeah, thank you, everybody. Thank you. Over to our moderator, ma'am.
Goodbye.
Thank you.
Okay. Thank you. Thank you very much, everyone. Thank you so much for joining us today. We truly appreciate you. We thank you, and we hope that the next time we call on you, you will come. Thank you, and bye.